The next case is William J. Rice versus DARREN, DARWENT, and ZANNAROITMAN.
Am I done here?
You're through, yes, sir.
Thank you.
May it please?
Do you wish to reserve any time, sir?
5 minutes, Your Honor.
You've got 5 minutes reserved, sir.
Thank you, Your Honor. May it please the Court, my name is Jack Shaw. I represent the appellant William Rice. This appeal arises from a summary judgment on 2 counts and a directed verdict on the remaining counts in a case arising out of a real estate transaction. My client, Mr. Rice, was the purchaser. Mr. Benitez's clients were the sellers.
Counsel, let me clarify one thing. My understanding that we didn't have a transcript of the trial. Is that an accurate statement?
I believe that has been added to the record in the last few days. It had been not forwarded by the clerk's office, the circuit court clerk's office. And yesterday's mail, I received the notice that it had been transmitted.
Well, I don't think we got it before this, unless...
I don't think we have it yet, but it's coming.
Okay.
We arranged to get it as soon as we discovered that it was sitting there and the clerk made the mistake.
Yeah. So it was included in the record, just for some reason it had not gotten here, but
Okay,
apparently
well,
has been now.
I'm sorry to interrupt you. I just want to make sure I understood that there was a... I wasn't advised that there was a record on its way. I was just told that there was no record, but I'll accept the fact that it's either here or will be here shortly.
That's
So
my
please
understanding.
proceed, sir.
Thank you. As I was saying, Mr. Rice was the buyer of this particular piece of property. Mr. Benitez's clients were the sellers. During the inspection period provided for in the contract, Mr. Rice learned that there were building code violations. He demanded that they be cured. The sellers refused to do so. They refused to go forward with closing at that point. Mr. Rice filed a suit for, well, by the third amended complaint, it had, I think, 6 counts. First count was for specific performance, second count for breach of contract. Trial judge entered a summary judgment on those counts in favor of the defendants. Case proceeded to trial on the remaining counts and a directed verdict was entered.
Mr. Shaw, let me ask you this question. Judge Perry made a comment that this contract has the words "as is" all over it.
That's correct, Your Honor.
Is it your position that that "as is" clause doesn't apply to code violations?
That it is, Your Honor. That's exactly our position. Get direct.
Why?
Okay. The as-is rider provides that it shall amend, modify, and be a part of the contract. In paragraph 1, the parties agree that the property is sold in as-is condition.
Why doesn't that include code violations?
I'm getting to that right now, Your Honor. Sorry. Paragraph 2, paragraph 2A, specifically deletes paragraph 5 and paragraph 12 and paragraph 5B of the remainder of the contract. It does not address paragraph 9 or paragraph 32, which are what we place our reliance on. But
isn't there a provision in there that says that an addendum like that overrides any other typewritten provisions in the contract?
No, Your Honor, there is not. And if you look at the Spyrud case out of the 2nd District, a 2003 case.
I want to look at the contract first, because I think you're saying that contract doesn't have that in it?
I'm saying that it says it'll amend, modify, and be a part of. And it only amends to the extent of any inconsistency.
Well, go ahead with your argument.
If you look at the Spyrud case, which is out of the 2nd District.
So your position is that as a matter of law, an as-is clause isn't inconsistent with the failure to disclose building violations?
Correct.
What difference does it make if you didn't buy the property? Where's the reliance? Where's the damage?
The damage is that under the contract, as we understand the contract, Mr. Rice had a perfect right to say, if there's termite damage, that's fine, I'll take it. But if there's a building code violation, it has to be cured. And the seller has obligated himself to cure the building code violation in paragraph 9 of the contract. The seller's warrant: at the time of closing, there shall be no violation of building or zoning codes. Seller shall pay for expenses required to bring the property into compliance with such codes at time of closing, subject to...
But there was no closing because your client refused to purchase it as is.
There was no closing because the sellers refused to comply with paragraph 9 and fix the building code violation.
But they didn't have a duty to fix the building code violations unless your client agreed to purchase it as is. Don't you?
No, Your Honor, I think I understand the question you're asking. It's our position that under this contract as written, if there was, for instance, an old roof that needed repair, Mr. Rice could either take the property as is or walk away from the deal. But the specific provisions of paragraph 9 still control that if there's a building code violation, that's an exception to taking the whole thing as is. And the Rayner case out of the 1st District and the Swirud case out of the 2nd District address that issue. And specifically, I believe it's the Swirud case, yes, the court said that nothing in the addendum specifically referred to, in that case, the Johnson warranty provision, which would be paragraph 32 in this case. And although the contract was the functional equivalent of an as-is contract, that did not waive that duty. That did not waive that provision of the contract. The contract can be interpreted as is, except for building code violations. And that is precisely what we believe this contract holds. That if there is a building code violation, it is the seller's duty under paragraph 9 to fix that violation. And if the seller refuses, he has breached the contract. And he has violated paragraph 9. If he has failed to disclose, he's also violated...
If you're wrong about that, you lose this appeal, don't you?
Yes. That's simple. That's why I wanted to address that issue first. There are a number of other issues, as you'll see in the case. Candidly, if we were wrong on that, the other issues go away. And that's why I want to focus on that issue. Sellers warranted in paragraph 9 that there would be no building code violation and that they would fix any building code violation. The as-is writer deletes paragraph 12. It deletes paragraph 5b. Nowhere does it refer to paragraph 9. Nowhere does it refer to paragraph 32. Those parts of the contract are still very viable. And that was the point in the Swirud case. In that case, it was involved with some mildew damage and structural defects. It's a typed addendum, a 3-day home inspection period, and the buyer could walk if he didn't like what showed up in the inspection. In that case, the as-is provision specifically referred to other provisions of the contract, but not to the provision which corresponds to paragraph 32 of this provision. Yes, Your Honor.
Counsel, let me back up a minute. There's a provision in here in the contract right towards the end, and unfortunately the contract copy that I've got doesn't show the number of it, but it says entire agreement, typewritten or handwritten. And it effectively says that any writer that's attached shall control all printed provisions in conflict therewith. And your argument was the contract says that it includes or implies it, but this addendum that's issued or that's attached to it negates that, seems to me.
Only to the extent of conflict, Your Honor. That's my point. And that was the point in the Swirud case. If there is a conflict, yes. But there is no conflict here. The contract can be very simply interpreted as being as is, except for a building code violation.
But the conflict is in the fact that you're taking a position that building codes are covered by it, and this seems to negate that by saying that it's an as-is sale.
Your Honor, well, the point I'm trying to make, and apparently not very successfully, is that...
I understand your point. I'm just trying to... where I'm having a problem with trying to factor it into this decision.
If there is a conflict between the writer and the underlying contract, the writer prevails. But our position, as in the Swirud case, is that there is not a conflict in this situation, that there is room for both, just as there was room for both in the Swirud case. In that case, there was an as-is provision. It prevailed over conflicting provisions. The Second District looked at the contract and said, there's room for both. You can have both. Here you can have both. In that case, it was a Johnson versus Davis warranty clause that was involved. We have one of those involved here too. But also paragraph 9 is very clear. It is making an exception to the general as-is language, if you would, saying in this particular situation, here's what happens. There is room for both. If Mr. Rice had done inspections and found a bad roof or termites, he was free to walk away. That was his only remedy. But building code violations are a different thing. Building code violation, you might have to tear the whole structure down and rebuild it. There's a very good reason for making that an exception.
Maybe grandfathered in, but he certainly has the ability to determine whether there are any building code violations, doesn't he, with an inspection?
The inspections are what revealed the building code violations.
Then he can evaluate what the cost to remedy that might be, or if it even can be remedied. And if that's the case, then he can either walk away or go ahead and buy it and do what he needs to do to bring it into code.
No, Your Honor, I think there's a third option under this contract. He could walk away and say, never mind. He could say, it's a minor thing, I'll take it as is, here's your money. But he also had the option, which he tried to exercise, to say, everything else, fine, but the building code violation's got to be fixed. And that's what paragraph 9 requires. Seller shall pay for the expenses required to bring the property into compliance. And the sellers refused to do that. Under the contract, that was his right.
Is there anything in the record that shows what the code violations were, or how much would it cost to correct them?
There are some things in the record. There's an affidavit from Mr. Rice indicating that the roofing inspector, the plumbing inspector, and I believe the electrical inspector all reported code violations in their areas. There is something in the record, and I don't recall if it's a representation of counsel or if it is actual evidence indicating that the cost of doing so could be as much as $50,000. This was a sale for, I believe it was $700,000.
But for purposes of your argument, it doesn't matter.
Correct.
A person can offer to sell a house as is, but under your interpretation of this provision, if the house was originally built without a building permit, then the house has to be torn down and rebuilt at the seller's expense, and he's got no option because of the buyer's interpretation, your interpretation of the application of the as-is clause. Does that make any sense to you at all?
Yes, Your Honor, it does. I think that the seller could have said, I'm not going to sign that contract unless you specifically exclude that provision. There's always that option. They had no need to sell the property. Free market. It's not a foreclosure sale or anything. You can negotiate the terms of the contract. They negotiated the terms of this contract. Mr. ROITMAN was involved in changing some of the original terms. I think it was at time of closing and some other minor things. He could simply have said, take that provision out, but he didn't.
One of the things that's causing me a problem, I live in a 40-year-old house, and we've had some electrical work done recently, and the electrician said there's a lot of your electrical things that are not up to code, current code. And I said, well, are any of them dangerous? No. Is anybody going to come along here and, make us tear the house down? And that wasn't the case either. The codes change almost from year to year. And I dare say that there's very few houses over 10 years old that don't have some element in them that is a violation of the code. And I think that that's exactly what the seller in this case was trying to protect himself against, was having to go back and bring something up to code.
Well, I think the problem, Your Honor, is not the same factual scenario as you presented with the 40-year-old house. Mr. ROITMAN had done extensive work on the house. It's detailed in the brief, the house and the guest house, and apparently had not pulled any permits for any of it. Some of it he felt was cosmetic and didn't need permits. But Mr. ROITMAN knew of what had been done within the last, I believe, within the last year prior to this transaction. So it was not a matter of being worried about something that had pre-existed for years. The question was whether the work he had done himself was up to code, complied with code. And I think Mr. Roitman, certainly had I been in this position, I would have said, you know, I'm not guaranteeing that this stuff is up to code because I did it myself, did it with the help of friends. I'm not going to sign with that provision in there.
But your interpretation basically changes the meaning of as is. As is generally means as is. If you want to change that, would it not be the better practice in your as is addendum to specifically say that this property is being sold as is with the exception of building code violations? Because if you don't do that, then as is does not mean as is.
Certainly the contract could have been written that way, Your Honor. Certainly the contract could have been written to specifically exclude these two paragraphs. Unfortunately, we're stuck with the contract as written. Thank you, Your Honor. I'll reserve my remaining time.
Good morning, Your Honors. My name is Gus Benitez. I represent the appellees in this case. And Judge, the focus is paragraph 9. But to just show just how unreasonable that position is, they don't want you to just declare paragraph 9 to have survived the as-is rider. They want you to go back and reinterpret the contract to include paragraph 9 as a new provision with new life and new meaning. Because what they are also pointing out to is that the section in the addendum, which then deletes paragraph 12, which has a limitation to the liability of the seller under paragraph 9, they want that totally omitted. So what they want to do is redraft the contract to read now, we are going to go ahead and sell this house as is, and we're going to give them an inspection period of 20 days, and we're going to give them an absolute right to leave under any pretense during those 20 days. But on top of that, if we decide to inspect it and we find code violations, and we find them to be in the range of $50,000 to $150,000, which is what is before the court on the record through the affidavit of the sellers, that then we are going to require you to make those corrections or give us that amount, $50,000 to $150,000, even though paragraph 9, if it did not have the as-is rider on it, would have been limited to 4% of the purchase price. Absurd. And that's the case, Judge. And we've been litigating this for 2 years, and these people have been stuck with this house for 2 years. And I hope that this court renders a decision expeditiously.
Thank you, Counsel.
Thank you.
Very briefly, Your Honor, the as-is rider does provide that paragraph 12 was deleted in its entirety. Mr. Benitez is correct in that. It did have a 4% limit prior to that. With an as-is provision, let me back up. Normally, you would have a limitation because you would have to make various repairs for cosmetic things. But by deleting paragraph 12 in its entirety, it did delete that 4% limitation. It also changed inspection rights and did a lot of other things. And yes, he's correct that the sellers would be required to pay whatever is necessary. But that's what they agreed to do, Your Honor. That's what they agreed to do. Paragraph 9 says. Thank you.